Hello, everyone, and welcome to the webinar, Regulation Best Interest, Practical Steps to Take Right Now, featuring Paul Murdoch and Gus Macedo of MCG Consulting and Jeff Childs of MCO. A recording of today's session will be made available on MyComplianceOffice.com. We'll send you an email in the next few days with the link to download the recording and slides. If you have a question for us, please send it to us via the chat button at the bottom of your screen. We'll be answering some questions after the presentation. And now, I'd like to kick things off by welcoming Paul Murdoch, Managing Director of MCG Consulting. Paul, over to you.
Okay, thank you, Louise. Welcome, everyone. Thanks for joining us today. We look forward to providing the information on where we are from a practical perspective for Reg BI. So my name is Paul Murdoch, Managing Director of MCG, and we have Gus Macedo that will be presenting with us today as well. Next slide, please. Hi, so I'm not going to spend a lot of time on my background, but I'll just let everyone, that has joined us today know that I've been in the business for over 25 years. I've spent time as both the Chief Compliance Officer with Prudential and BlackRock, and I've been consulting or working for consultant firms running E&Y and Wolters Kluwer and now MCG. For the last 10 years or so. And Gus?
Next slide, please. Good afternoon. I am Gus Macedo. I've been in the securities industry for over 25 years, like Paul. I've worked for both the regulators and the private firms. I've started my career with the SEC and ended it with, well, not ended it, but worked with Calvert Investments. And now I help regulated entities implement regulatory directives. Next slide.
Next slide. So just wanted to give the audience a little bit about MCG. For those of you who don't know us, obviously you could always go to our website and find out a lot more information. But in general, we offer a range of consultant solutions designed really to help your firm in various aspects. And we can design bespoke solutions for you, as well as provide regular guidance. Next slide, please. And this just outlines some of our services, focusing on compliance, transaction monitoring, regulatory reporting, risk management, project management, and ID management and control. So as I said, feel free to go to our website or give us a call. Next slide, please. Okay, so at this point, I'm going to turn it over to Gus. Gus is going to take us through some of the regulatory background and how we actually got here. Gus?
How did we get here? There were many factors that contributed to how we got to regulation best interest. I mean, there are two different standards that broker-dealers and investment advisors operate under. BDs have traditionally operated under the suitability standard, while RIAs have operated on the fiduciary standard. In 2010, the Dodd-Frank Act instructed the SEC to study, recommend, and design a uniform standard of conduct that were designed for retail investors from both broker-dealers and investment advisors. The SEC issued a report that acknowledged that both broker-dealers and investment advisors operated under a different regulatory regime. So the SEC found that retail investors generally were not aware of the differences of the legal implications. In fact, many investors were confused about the different standards of care that apply to investment advisors and broker-dealers. That confusion had been a source of concern for the regulators and for Congress. From after the SEC considered what they had found from 2011 through about 2016, the SEC considered what to do about those two different regulatory schemes and how to put them more in line to serve the retail clients. But those conditions that existed during that time period failed to adopt any uniform standards for both broker-dealers and investment advisors. So in 2018, under Chairman Clayton's commission, the SEC proposed Regulation BI, and in 2019, the SEC adopted Regulation BI, which definitely changed the standard of conduct for broker-dealers and implemented Form CRS, both for investment advisors and for broker-dealers. The standard that was put in place for broker-dealers require broker-dealers to put the interest of the clients ahead of the broker-dealers' interests. And it required firms to provide to clients a simplified plain English document called Form CRS with 5 questions on there to be answered and a few conversation starters that the investor and the broker-dealer or associated person must discuss with the client. So next slide, please. Form CRS and regulation best interests have to be implemented no later than June 30th, 2020. Firms can submit, the earliest that firms can submit their Form CRS to the SEC is May 1st. So for those who are inclined and eager to show or demonstrate compliance, you have May 1st. Clients have to receive your Form CRS no later than July 30th. So between now and the implementation date, you have about 2.5 months to comply with that requirement. Next slide, please.
Hey, Gus, before we go there, if I could just interject,
Sure.
for those of you that don't know, you should be aware that FINRA has already started reaching out to firms and have already started doing best interest reviews. Some on the call may have already received some of those calls from FINRA. At this point in time, it's kind of a let's look and see, let's kick the tires, let's see what firms are doing. They're not really looking to sanction firms at this point, but really just getting a sense of where the industry is. So that's a good lead into this slide, which is a random survey that was recently taken by us, where we polled the industry just to get a sense of where people were and what people are thinking. So as you can see, of the folks that responded, 42% were dual registrants, which will create an interesting dialogue as we go further into the presentation in terms of how dual registrants will need to prepare maybe a little bit differently than the rest of the firms. We see that 60% understand and are prepared for the rules in accordance with this survey. So the data is the data, so I will use that as an indication, but I could just tell you anecdotal evidence from myself talking to the industry out there. That number may seem a little high. But we do have 2 months to get there, so I'm sure there will be a rush to the finish line, so to speak. As we can see, the resources that are being used, 69% plan to utilize internal resources. And once again, I just want to caution that because I know the survey is still a few months ahead of the deadline. So as we talk about planning, that view may shift as we get closer. Next slide, please.
So we see that the standard of conduct for broker-dealers is a higher standard of conduct. Anyway, so regulation best interest is an overarching obligation for broker-dealers to establish and comply with certain component obligations. And I characterize those component obligations as 5. You have the best interest obligation plus 4 additional obligations, which are disclosure obligation, care obligation, conflict of interest obligation, and your compliance obligation. The best interest and recommendation are not defined by the SEC. In fact, the SEC says best interest is based on the facts and circumstances of how broker-dealers have satisfied the 5 component obligations of Reg BI at the time a recommendation is made. Retail customer is any natural person who receives a recommendation for securities transaction for personal use. General, that is the definition. Next slide, please. So a broker-dealer must establish each component obligation to comply, to demonstrate compliance with regulation best interests. So all 5 of those compliance component obligations must be satisfied at the time that a recommendation is made. The SEC's Division of Trading and Markets has issued a broker-dealer FAQ on the following topics. Discuss retail customer, recommendation, disclosure obligation, care obligation, conflict of interest obligation, and the compliance obligation. One question that has come up, and I think that many of the industry is trying to get their hands around, is this disclosure obligation. Broker dealers are trying to figure out whether they can satisfy the disclosure obligation under Reg BI with the form CRS, with that relationship summary. The SEC generally has said that, in order for a firm to satisfy would depend on the facts and circumstances. However, they believe that in most instances, the firms will need to provide additional information beyond the summary information contained in the relationship summary in order to satisfy that disclosure obligation. So firms are permitted to create an additional document, what we call, some people refer to a catch-all disclosure document that'll disclose their responsibility under this disclosure obligations. Some are going to create a regulation best interest disclosure document as a supplement or to support the disclosure obligations. Others are going to create a sort of like a layer disclosure document that is linked in the form CRS, and that is linked to other documents that a broker-dealer may use, such as your new account opening documents, your what else? Your margin agreements. All of those will have different disclosure obligations, or you can create one form and update those forms as you go about. Some people are going to use, the combined approach where they create a Reg BI disclosure document, and they also use the layered linking approach to the form CRS. We had and then we're going to go on to the care obligation. Firms are trying to figure out how they can go about satisfying this care obligation. How do they document recommendations to demonstrate satisfaction of this care obligation? What I like to direct your attention to is that when you think about care obligation, think about risk. What are the important factors to consider about a particular recommendation? What those factors, should include, the security, the investment strategy, what is this client's objective, the characteristics. You think about liquidity, you think about volatility, you think about the likely performance of this particular investment, the expected return, and how I mean, think about how now broker-dealers determine how they currently memorialize their recommendations and come up with a formalized process of memorializing those recommendations, particularly with respect to how risk is evidenced. So that's how you may consider figuring how to memorialize your care obligation when a recommendation is made to a client. The next component obligation is the conflict of interest obligation. Now, many investment advisors have already documented their conflict of interest. As a matter of fact, they have been under the fiduciary standard since their inception, and they have to disclose what those conflict of interests are to the clients, and they have to demonstrate how they're mitigated, and to a certain extent, you know, how some of them have been able to eliminate those conflict of interest. Well, so this conflict of interest with respect to broker-dealer is probably an overarching requirement to establish, maintain, and enforce reasonable policies and procedures to identify and at a minimum disclose what those conflicts of interest are. And in certain circumstances, eliminate those conflict of interest, especially if you have a firm that offers a proprietary product and that proprietary product is actually part of a sales contest. How do you demonstrate that that particular sale of that recommendation or that recommendation to that client is in that client's best interest? You have to decide what the conflicts are with respect to that and whether those conflicts have been eliminated. So that's something that you have to consider, and it's something that you should be currently right now inventorying and copying and making sure that you have your arsenal of conflicts of interest and how you're going to mitigate that. And your policies and procedures are in place to demonstrate how you assemble them, how you mitigate them, how you memorialize that you resolve them. So those are the component obligations. And also you have the compliance obligation. The compliance obligation is that you should look at your compliance policies and procedures to make sure that you have certain processes in place to comply with regulation best interest, and specifically how you comply with these 5 component obligations of Reg BI.
Hey Gus, I've a
Yes.
question for you here because you serve on the Reg BI committee for NSCP, so obviously you're hearing a lot from firms are struggling with. Of these obligations that you're outlining here, which one or two would you say is the most discussed or more concerned by the firms that are a part of that committee and the industry as a whole? If you
Yeah. So you know that's a tough one. What? Oh, yeah. You know, if I had to, you know, without a scientific, uh, uh, poll, I would probably say the conflict of interest obligation and that disclosure obligation are probably 2 of the most discussed items, because, you know, again, traditionally broker dealers have not disclosed what their conflicts have been. So now they have to go back and actually look at the business model and determine what those conflicts are and memorialize those conflicts and try to map them to their compliance policies and procedures and try to figure out how they're going to create policies and procedures to manage those conflicts and how they're going to eliminate those things. That's one. The other one is coming up with a disclosure document that discusses those compliance, those conflicts of interest, and whether it meets and or exceeds what the regulators would consider to be an appropriate disclosure document.
great, great. Thanks for that.
So let's move on to the next slide. Okay. Form CRS. Form CRS, I mean, it's no, we've talked about this. Investment advisors and broker dealers are required to disclose certain information in the form CRS and they have 5 questions that they have to respond to. If you're a duly registered if you're a duly registered registrant, you or can elect to disclose or use a 4-pager to describe to comply with these requirements, or you may elect to create 2 separate documents to file, one for your broker-dealer and the other one for your investment advisor. Chairman Clayton, again, has come out and said, folks, especially in these times of uncertainty, investment professionals should not put their interests ahead of the interest of their clients and customers, and has said that the SEC at this point, as of April 2nd, when he made this announcement, will not delay the implementation date of Form CRS in Regulation Best Interest. So I think many of us are jumping into high gear trying to definitely meet this deadline. So next slide, please. So right now, what are the recent considerations that firms are being exposed to? The SEC came out, I should say, OC came out with a couple of alerts and said that industry, after June 30th, more than likely it'll be after July 30th, where OC will begin to examine BDs to determine how well they implemented their regulation best interest, try to look at their operational effectiveness. They will focus on their policies and procedures to comply with regulation best interest. So in addition to your review of your current compliance policies and procedures, you'll have to develop new compliance policies and procedures, establish them to determine how you are going to comply with Reg BI, which will be embedded and will permeate your entire compliance program. OC also wants to find out the kind of progress that firms made while they were implementing the necessary policies and procedures. They want to see whether firms, actually took the implementation of Reg BI seriously in Form CRS, or they took a nonchalant approach to the implementation of this regulation. Remember, let's go back to history. Investors, particularly retail investors, do not know the difference between broker-dealer and investment advisor. What they know is that they have a professional, a financial professional that provides advice to them, that manage their assets. And whether the standard is a suitability standard, which will soon be a best interest standard, or a fiduciary standard, have meant nothing to them. They treated it as one, that this financial professional should act in the best interest. And the SEC wants to make sure that their regulation, that they think is important, will help retail investors. All right, so after the current administration came in, and there was a whole lot of pushback and litigation and so many other things regarding the Department of Labor fiduciary rule that applied to retirement plans, and they basically dismantled or said that it was illegal for the Department of Labor to implement such regulations. Certain states that believed that the Labor Department's fiduciary standard was in fact the right standard for them decided to go ahead and pass legislation and adopt a fiduciary standard that applies to broker-dealers. So Nevada was the first state that came up with a statutory fiduciary duty for broker-dealers and investment advisors. Now, Nevada hasn't come up with a regulation to implement the law that was passed in 2017. Massachusetts, on the other hand, Securities Division just recently finalized their BD rule that applied the fiduciary standard to broker-dealers who are making recommendations. There is a whole lot of discussion that is ongoing currently about federal preemption, meaning whether the federal law would bar the state of Massachusetts from instituting a law that will protect the citizens of Massachusetts. That'll be duked out in court at some point, depending on how zealous the sides are about the law that was or the regulation that was implemented in Massachusetts. We'll wait to see. But for now, to the extent that you make retail recommendations to clients in Massachusetts, I would suggest that you treat your relationship with your clients in Massachusetts as fiduciaries. New Jersey has a proposed regulation also that would apply the fiduciary standard duty to broker dealers. That is still pending, and we don't know when that will become effective. There have been many industry participants who have been opposed and are in fact are trying to encourage, I should discourage the state of New Jersey from moving forward with that fiduciary rule. Next
Gus,
slide, please. Yes, sir.
before moving to the next slide, if I could just ask you for the can you go, Luis, can you go back to, yes. If I could just ask you, as a non-lawyer in the room, what is the nuance between the statutory fiduciary duty under Nevada law and common law fiduciary duty under New Jersey that they're proposing? Is that something that, as a broker dealer trying to figure all of this stuff out and the disclosure, I should be particularly concerned about or at this time?
I would tell you that you shouldn't be concerned with it because they will have to give us notice of what that fiduciary duty is, and it'll have to be and they'll say, okay, look, like Massachusetts did. Massachusetts defined what fiduciary means. Traditionally, under common law, the courts have defined through cases what fiduciary means and what that fiduciary standard is. So, New Jersey is an old line state and they operate under, common law. And so they're saying in order for, I guess, those lay people like me and others say, okay, look, we're going to adopt a fiduciary rule that will apply to broker dealers. They will tell us exactly what those are. For example, when the Department of Labor proposed what a fiduciary standard was and who were fiduciaries, they defined that within their rule. So that will be similar to what New Jersey will do when New Jersey adopts such a rule.
Great.
Yeah. So let's go to the next slide, and I will turn this over to Paul.
Okay, great. Thanks, Gus. So, what are we hearing from clients out there about Reg BI, some of the concerns, what have you? We'll just go through some of them here. So, how will one distribute Form CRS? How are you going to distribute it to clients? Determine which clients it's applicable to, that sort of thing. So there's obviously concerns about that and how you would distribute it, and when you would give notice. So obviously June 30th is the deadline when you can give notice, so you can distribute it by sending out the Form CRS to all of your clients. And it's not just new clients, it's existing clients. So folks should be aware of that. I think Gus mentioned before also that it could be hyperlinked, so you can distribute it over your website. So that's another form of distribution. But I think basically what we're hearing for the most part is that firms will be sending out the Form CRS to everyone come June 30th. some things about the products, the difference between suitability versus Reg BI. I think Gus touched on that when he spoke about kind of the evolution of the rule and how we got here. But once again, these are things that in the industry customers are discussing. The impact between various products. How will we disclose, let's say, who's applicable for Reg BI? What does it mean when you look at various products, mutual funds versus ETF, for example, in just this case here that we have up on the screen. But there are many kind of nuanced things that firms are beginning to think about, discuss, and these all go back to the conflict standards that need to be disclosed and the disclosure standards as one creates the form. We talked about distribution, how we'll distribute the form, and advisor with affiliate relationship with BDs. What does that mean in terms of Reg BI itself, and how will you deal with this? And once again, that comes back to what Gus mentioned about disclosure obligations and how you're going to deal with it. So those are some of the things that we are hearing from clients, and we'd love to hear more from you today, by giving us some questions that we could respond to live. Next slide, please. Implementation guidance. What are clients' reactions to Reg BI and approaching June 30th deadline? Well, you saw from the data that we put out kind of what people are thinking and their approach, and I guess the concern for the June 30th deadline and any anxiety that that may be going through the industry, and as you guys think about it, as you deal with it every day, I'm sure you're trying to figure it out just like everybody else, and trying to figure out how you're going to make the June 30th deadline and what resources you're going to implement. So another bullet, BDs and RIAs have reviewed their business practices. We're beginning to see that people are really beginning to focus on that now, because once again, without doing that, you're not going to be able to mitigate all of the conflicts that you need to manage and disclose, which leads into the second bullet there, which is identification and mitigation to the extent that's possible. And the form itself, draft and adopt and implement policies and procedures to ensure that you're in compliance with Reg BI. As I mentioned previously, FINRA has already taken their approach that they are looking at what firms are doing now and giving some feedback. So if you haven't heard from them, you might, because they're very focused on this. I think we should also realize the backdrop that we're in with market volatility that we're having with respect to the small investor, that this will be something that will be a focus for some time to come from both SEC and FINRA itself. BDs and RIAs have began drafting some of the forms, so we've been taking a look at what some of our clients are drafting and giving recommendations on how to beef those up as well. So those are some of the things that we are helping clients with, and those are the daily struggles you guys are dealing with now. Next slide, please. And once again, I think we touched on a number of these things. How will they implement the distribution of the form? How will they distribute the form to the clients? Gus, was there anything I did not cover that you want to add here?
No, I think you've covered it. Yeah.
Okay. Next slide. Okay, so I'm going to turn this. It's great speaking to everyone. I look forward to some of your questions, but I'm going to turn this this presentation over to Jeff Childs at this time.
Thank you, Gus, and thank you, Paul. Again, my name is Jeff Childs. I'm Director of Sales with MyComplianceOffice. And for the next few minutes, I'd like to provide a high-level overview of MCO for those of you who may not be familiar with us today. At our core, MCO, we're a SaaS-based technology vendor that helps firms mitigate conflict of interest or conduct risk around employee, firm, and third-party activities. Ease of use is paramount at MCO, and as a vendor, it's our goal to make technology simple. That's why we designed our system to be extremely easy to use from both the supervisor as well as the employee perspective. And we didn't design this in a vacuum. We received lots of feedback, lots of input from clients and consultants, which has really helped pay off as we continue to receive high marks for ease of use. MCO is also proven. We were founded in 2008 as a spin out of Fidelity. We now have over 400 customers worldwide using our products. The company is headquartered in Dublin, Ireland, with offices in New York City, Dallas, Fort Worth, as well as Singapore. As a global company, we have data centers in the US and the UK and offer business support 24 hours a day, 5 days a week. We're very proud of our 97% client retention rate. There are many commercial options available today, but our clients choose to remain with us, which is really a testament not only to our software, but to our customer success as well as our customer support teams. Next slide, please. As this is loading, this is a diagram of our product suite. Our products are delivered from one single platform, allowing us to build out our existing products, which easily means adding newer modules. At the heart of our solution is the Compliance Program Manager, or CPM. This is the core engine where the rules, the task management, the workflow, and emails reside, which are then shared across all the modules. Sitting on top of the CPM are 3 product suites which can be licensed together or licensed independently. I'm not going to go into the details of every module, but I will mention those that may be of interest to the audience today. At the top center, KYE, or Know Your Employee, this is our flagship product to manage employee conflicts of interest. A few of the modules that make up KYE include PTM, our personal trading manager, which reviews employee trade requests against company business rules, such as a restricted list. Attestations allow for the creation of any type of certification, any type of questionnaire, any type of course, attestation. OBA, our outside business activities module, allows for the capture of employee outside business activities and affiliations, and ARL, our authorization, registration, and licensing module, tracks employee licensing, registration, and also integrates with FINRA. On the left-hand side, KYT, or Know Your Transactions, provides a suite of company transaction surveillance modules. 2 modules worth mentioning today. The Suitability Manager compares investment activities against client objectives to ensure brokers are not putting clients in securities outside of their stated investment objectives. Our MNPI and Insider Information module tracks the receipt of material non-public information associated with an investment banking deal or a private investment transaction. The third product in our conduct risk suite is Know Your Third Party, or KYTP, which is on the right-hand side. Our third-party manager tracks the risks that third parties such as vendors, customers, and suppliers bring to your business. The client lifecycle manager, while similar to the third-party manager, tracks the conflicts between your third parties and employee activities. Next slide, please. Now, you might ask how we are able to track conflicts across the firm. Well, to effectively monitor and detect employee conduct risk, clients need a way to leverage data from different sources. Oh, can you go back? Yep. Data is often siloed, making it very difficult to know what is happening across the firm. Because our products are delivered from one single platform with several data master files, we can connect the dots across employee activities and relate employee information against the firm or third parties. In other words, compliance can now find those needles in the haystack that are literally impossible to find when using different vendor solutions or when doing this manually. As an example, does an employee have an outside affiliation with a vendor or a supplier that the company is about to onboard? are reps placing clients in investments that they've purchased for themselves. Clients now have a full picture of employee activity where every employee is compared against the rest of the organization. So Louise, that concludes my part of the presentation. Can you forward to the contacts? Or first we can take questions. And I see some questions that have come through. So I think it's probably best that I read these in order. And Gus, Paul, obviously these are for you. So the first one says, in light of Reg BI, are some broker dealers considering operating under the fiduciary duty standard?
Wow. Well, uh, I think some firms are contemplating that because Reg BI has brought the standard of suitability almost as close to a fiduciary as you can, but haven't gone the last, I should say, mile or the last yard to decide to become a fiduciary, and that's something that they may want to consider. But so far, yes, I haven't heard from a client that has said, I have decided to become a fiduciary, operating as a broker dealer. So that's interesting, huh? Okay. We
Okay.
will, yeah. All right.
Another question. Are duly registered firms considering filing jointly Form CRS?
Yes, many dually registered firms are because they've operated on different standards, and they haven't exercised haven't gone through the exercise of identifying what the conflict of interest are and memorializing those, and the models are different. They are considering, for simplicity's sake, considering creating separate Form CRS because the products that they offer are different and the services are different, and they want to keep those different. Although they're going to identify who their affiliates are, they don't want to confuse their clients and or their associated persons. So many are. So especially for, I would say, insurance affiliated broker dealers that also have an investment advisor arm, they are considering filing separate documents because the broker dealers are and often are primarily the primary distributor, underwriter of the insurance products that are sold through the broker dealer. Whereas the investment advisors manage the assets of some of those clients that own insurance products. So so far they're going both ways, individually and jointly.
Okay, another follow-up question to that. As a dual registrant, if I file a Form CRS for each entity, what are some of the things I need to be aware of that may be different for each entity?
Well, first, I mean, the standard that you are operating under, for example, the fiduciary standard for the investment advisor versus the best interest standard for the broker dealer. The compensation structure of the broker dealer versus the compensation structure of the investment advisor, proprietary products of the broker dealer versus non-proprietary products of the investment advisor. Those are some of the things that you have to consider when disclosing some of those considerations. And often, because of the models of broker dealers, especially those that serve retail investors, they have disciplinary history. And some investment advisors don't have disciplinary history, although they're affiliates, but the way Form CRS, they may have to disclose on their Form CRS that their affiliates have disciplinary history and create a link that will go to the particular disciplinary history that they have discussed in their Form CRS. Yeah. Next
Okay.
question. Yeah.
Yeah, it says, if I have a pending matter in front of the SEC or FINRA that will not be resolved prior to the June 30th deadline, do I have any disclosure obligation?
The firms should only disclose what is currently in place, what is currently effective. The SEC requires investment advisors to disclose currently what is in existence. They don't like you to disclose what you prospectively will do or plan to do. For Form BD and Form ADV. The regulators require what is currently the state of the affairs that needs to be disclosed, as opposed to what may be or is coming, is about to be disclosed. So those firms that have matters that are pending that may result in disclosure items in Form BD and Form ADV are required to wait until those disclosures are required to be disclosed in their respective forms, which may mean after they have signed agreements, settlement agreements with the SEC, or have injunctive relief imposed by the courts as a result of an SEC matter or judgment or AWC from FINRA. So they should wait until those items are finalized before they're disclosed. And it means that they'll just have to go back and amend their Form CRS.
I
So
don't see
that's,
any more questions that have come through.
wow,
Uh,
okay.
we have, I think, Louise, we have a couple of polling questions, right, that we'd like to ask the audience out there just to get some data points.
Sure.
So again, folks, while you're going through the polling questions, we just want to say that we appreciate the opportunity to put on this presentation for you guys today. And any additional questions that you have, feel free to send them in. We're happy to put together a FAQ and get that out to our audience as well. Great.
So Paul, here are results for our first poll.
Yes. Yes. Okay. Great. So we have 70% broker dealers, investment advisors, and a number of dual registrants with us today. So obviously, some of these questions that were asked were very apropos to your business. Second question. Okay, so let's see how prepared everyone will be for the June 30th deadline. Yes, so we would imagine that 68% still working on it is what we would expect. The majority of folks to still be considering, especially those conflicts and how you'll write up the form CRS. We are 2 months out, but there's still some urgency. I think there was a consideration or hope by the industry that Commissioner Clayton may have pushed the deadline back, given that we're in the middle of a pandemic. We see that as, in fact, not the case. Again, because of the concerns about retail investment in a volatile market. So that is consistent with what we were thinking. Next question. So describe your overall understanding of the rule itself and the specific requirements. Let's see what those results come back with. Okay, so we see kind of split evenly there between fair and good, which would be consistent with what we saw before from the survey results in terms of 68% we're currently working on it. And I think we have one more question. And that goes to resources. Wait for those results to come in. Okay. Again, pretty consistent with the survey results that we saw earlier during the presentation, where internal compliance department is doing most of the work. So you guys will be busy. You have 2 months essentially get that done, and in their interim, we're here to help if you need our help. So this is a great presentation. I enjoyed it. I don't have anything else.
Well, thank you, Paul and Gus and Jeff, for the informative presentation today. And thank you, everybody on the call, for your time. For more information on MCG Consulting, visit mcgcomply.com. For more information on MCO, visit MyComplianceOffice.com. We will send a link to the recording shortly. And if you have any questions for follow-up, please don't hesitate to let us know. Thank you again for your time and have a great day.